Hallelujah. Yeah, me be anyone you say. Come on over this building, lift your voice and worship Him. He's the awesome God, the soon coming King, the Alpha and the Omega. Lift your voice, everybody, yeah, yeah, yeah. Awesome God you are, awesome God you are, awesome God you are, a binti so, awesome God you are, awesome God. Hallelujah. Yeah, me be anyone you say. Come on over this building, lift your voice and worship Him. He's the awesome God, the soon coming King, the Alpha and the Omega. Lift your voice, everybody, yeah, yeah, yeah. Awesome God you are, awesome God you are, awesome God you are, a binti so, awesome God you are, awesome God you are, awesome God you are, oh binti so, everybody say, tell Him how awesome He is.
Good evening, family. It's such an opportunity to come your way once again. And I just want to wish each and everyone a happy new month. So soon we're in July, and we can't be grateful to God enough. I sincerely apologize for the technical hitch that we had earlier on. I just wanted to play a song, but unfortunately, for some reason, it just couldn't happen. So I sincerely apologize for that. July, it's here, just like I said earlier on, and we can all testify how good God has been to all of us and how wonderful God has dealt with all of us. And today we are going to talk about an important topic that we hardly discuss in our various homes, in our various communities. And I thought, we should have this discussion because this important topic has driven a lot of families apart. It has turned a lot of families dysfunctional. We've had a lot of people being evicted from their homes because of our traditions and certain cultures as well. So today, I'm so privileged to have with me a solicitor from Elkettas Associates, your solicitors, and she is Chidi Akunna, sorry. She's a qualified and practicing solicitor with Elkettas Associates solicitors and has worked with different firms to gain specialist legal experience in key areas of law. Chidi is passionate about preserving human dignity through her legal and volunteering work with various charities. Her experience spans into specialist areas such as litigation, conveyancing, family and immigration law, which she absolutely loves. She's also a legal career coach and supervises trainee solicitors on training contracts. She advises individuals, charities, and business on legal matters. If you want to actually connect with her, she's on LinkedIn, and also um, maybe in the course of the program she might leave her number so that if you have any legal issues, yes, you can contact her, and then I know she'll be more than happy to support you. So welcome to the Inside View, lawyer Chidi Akunna.
Yay! Good
Good
evening,
to have you on my
everyone.
show.
Good evening,
Yes,
everyone, and thank you for having me, Nana.
it's a pleasure as well. I know you're so busy, and for you to leave, your family and also your busy schedule to educate our community. I do not take it for granted at all. So thank you.
One
And
person.
I know that tonight we are going to be empowered and also be enlightened by what you're going to taught us. Yeah. So once again, thank you and welcome to
Thank
the program.
you.
Yeah.
Thanks for having me.
Yeah. As important as this topic is, today we are going to be talking about wills, probate, and testaments. And if time also permits us, maybe we might add trust to it. I mean, depending on what our beautiful solicitor, will offer us. As important as this topic is, Chidi, before we go on, okay, before we start today's topic, for the sake of our young girls who are watching us, we just want to know who Chidi is. I know I've read something about you, but in your own words, who is Chidi Akunna?
Okay, Chidi, thank you so much for having me. Chidi Akunna is a woman who wears many hats. Like you just rightly introduced me, I'm a solicitor. I do other things. I coach. I run an organization with my husband called Foundation for Family Affairs, and the mission is just to connect hearts and raise healthy families. And it's just so beautiful to see changes, remarkable changes in the lives of families, the people in the family, when as we go on this journey. So it's just been interesting doing life, and I think I'm loving it. That's me in a nutshell.
I like that. It's I just just like the way you say it, just enjoy doing life. That's amazing. Yeah. I mean, just share with us your formative years. I mean, the kind of family that you grew up in. That has shaped the kind of woman that you are today.
Okay. I am the second child of four children, second child, second daughter. I initially studied sociology. Yes, my first degree was sociology and anthropology. I mean, I loved studying sociology, and it's still a part of me. I still have to use parts of what I studied as a sociologist in what I do every day now. But I had always wanted to study law. So after 4 years studying sociology, I still had to enroll to study law. And I was glad when I started another degree in law. And it's been a journey, really. In a nutshell, there's so much to talk about, but I think just for the benefit of any young lady listening out there, I would want to say, believe in yourself, believe in your dreams. Don't give up on your dreams. And why do I say that? Uh, when after studying law, I mean, I really wanted to be a solicitor. It was a long journey getting here. It took me so long. It was a lot of turns, bends. I had to just work for free sometimes. I had to be with a firm that promised me a training contract for about a year and 4 months. And after then, I was told, oh, unfortunately, we're going through business development. That would not be possible. So I found myself having to start all over again. Those were years where it was very uncomfortable, very experienced, very sad. And then, I mean, when I started out to do this, I started out not taking a dime. And meanwhile, I had to pay to get into work. So sometimes to achieve your vision, it would cost you. But it depends on the price you're willing to pay for it. And I was willing to do that. Positive price, yes, nothing negative. So for me, it was about doing whatever positive thing had to be done to get this. And I mean, I'm grateful I stuck to it. today, I mean, it's always been my desire to add to human dignity, to see people believe in themselves again, to just get justice for people. And when I go around doing this, and like the talk I'm giving now, it's just so invigorating and exciting to see that I am able to make a contribution to a part of someone's journey. So don't give up on that dream. It might seem far-fetched, but give it what it takes. Keep trusting God. Yes, with God on your side, you will get there, but you must persist.
Wonderful. Okay, so we'll zoom into today's topic. Today we are dealing with wills, probate, and testaments. Chidi, before you just educate us on that, why don't people make wills? As important as this topic is, why don't people make wills?
Okay. Now, I mean, for some people, I think it would be cultural. There'll be cultural reasons, and I'll give you an example. I had a colleague one time call me. He's Caucasian. He had an African client, a single parent with one child. She had contacted him to draft a will on her behalf. And then it got to the point where he had to ask her, who will be your executor? And then she said, oh, yes, my son. And he asked another question. What would happen if your son predeceases you? So if your son dies before you, who will then be your executor? And she got very offended, really put up, she was like, God forbid, are you praying for my child to die? And when he called me to weigh into the matter, I was trying to explain to him the cultural shock there. But to him, it was like, come on, she's got to deal with it. Death is inevitable. So you have that part where some people think some people believe in the law of attraction. So they believe if I talk about death, then I'm attracting it. I don't want to talk about it. And sometimes it's just laced with cultural beliefs. Then there's the part which might just be that people are scared of facing the reality of drafting a will, the reality of the fact that you don't have much, because that's what a will also assists you with. In the course of drafting a will, you're able to see your assets. So you might get to the point where you might be in your 60s and you're thinking, how many more years do I have to work before retirement? Are you trying to say this is all I have so far? So there are people who are scared of being faced with that reality. So sometimes the thought of having to draft a will just feels uncomfortable to them. It's a very uncomfortable thing, very nerve-wracking to have to own up to the fact that I may not have been as disciplined as I ought to have been, through my working years. So that's another reason some people would want to back out on drafting wills. Yes.
Great. So on that note, what is a will? And then if you can actually explain, the various topics that, I mentioned about, a will, a probate, trust, and also testament. Yeah.
Okay. So a will is just it's what tells you. It tells you what will happen when you die. You have to put it straight. Now,
Sure.
what would happen to your money, your property, your possession when you die? A probate is just the administration of your estate. So the administration of all you've acquired, your possessions, your money, and all that. Now, a testament, it used to be the case that a will was different from a testament. So traditionally, it used to be that wills had to deal with real estate, while testaments had to deal with personal possessions like jewelry, clothing, things like that. But wills had to deal with real estate, anything land related. But right now, we don't have that anymore. I mean, in the 18th, 19th century, that was the case. But currently, you would see that for most documents, it would say the last will and testament of this person. Okay, so that's about it, pretty much.
Great. So, it's a bit confusing because
Yes.
some people see drafting a will as a dangerous mindset, just like you rightly said. So, who should really make a will?
Hmm. That's a very good question. Who should be drafting a will?
Yeah,
And I would say anybody. Okay.
anybody.
Now,
Yeah.
to everyone who's even watching this, you should have a will. Okay. Sometimes you see people wait until they think, okay, in my 20s, mid 20s, I don't have much. So why do I have to draft a will? I'm going to wait until probably my late 50s, 60s, and then I will draft something. But the truth is, you have something, right? So it is just right that you put it. The way I see it is, it will helps you be disciplined if you want to look at it from that point of view. So if you have a will, you're able to say, because some people when they get to 60, they're thinking, what have I really done with all the money I worked for all these years? There was a time my husband said to me, okay, we need to sit down and calculate how much has gone through our hands in our working years up until this moment. And
Very,
it
very
was so
frustrating.
shocking to see how much we had, actually touched, how much we had actually had to disburse. So what a will does is it just helps you be more disciplined with with what you have. So anyone at any age should have a will. You may not have much. Don't forget that wills ought to be reviewed every 5 years. Mhm. Okay, or if something sudden or there's a major change, if there's a major change, you ought to review the will. When I say major change, what do I mean? Say in the event of a separation or divorce, in the event of the birth of a child, yes, you ought to review that will. So with cases like that, you can't just make a will and say this is it for life. So as I go through life, of course, in 5 years, a lot would have happened. So I can always update that will. So you should make a will if you're watching us.
Great. We have, especially, like a lot of rich people, like in our community, most of them die without, making a will, and some do. So, what if someone dies without a will? What happens to the family, or what happens to
Okay,
the property that the person leaves behind? Yeah.
yes, that's very sad. But the thing is, if you die without a will, then it would be considered that you have died intestate. So at that point, intestacy rules would kick in. Now, what's intestacy rules? It's just the your closest relatives. So whoever survives you. So if you're married, it would be your wife, your husband or wife. If you have children and your wife predeceased you, then it would be your children. But there are cases where they try to look for people. They try to look for next of kin. They try to look for family members of this person, and they just don't find them. So in that case, what happens if you're in the UK? Then your estate just goes to the crown. When they say it goes to the crown, it now goes to the king. You know, so it's really a sad thing, and that's why it's really important that you draft a will. A will gives you the opportunity to state expressly who you want to benefit from that will. There might be people who made a remarkable impact on your life at some point. Probably they would never have known that impact touched you so deeply. So you would think, I would like to make provision for them in my will. So that's an opportunity. But if you die intestate, then they lose out, isn't it?
Sure.
Yes.
Oh, okay. So, you know, having explained what a probate is, what are the things that are, affect probate? What are the important things that really affect probate?
Probate.
Yeah.
Okay, so a key one is usually the issue to do with executors. So what
Okay.
would happen? I'll just go back a bit and then come back to that. What usually happens when you have to draft a will, like with the example I gave earlier, we would have one of the first questions we ask is who would be your executor? Now you're allowed to have at least two executors. You can go as high as four if you want to. But then the question is, what happens if your executor dies? Okay, and that's why they would often encourage that you have two executors. And by the way, you can have professional executors as well. When we say professional executors, they could be solicitors, and you just have to pay a very insignificant fee for their service. So going back to will now, to probate. on your demise, your executor is responsible for administering your estate. So what that entails is they have to sort out your tax, they have to sort out your debts. So they look at your estate, whether you have a will or not. So they consider how much debt you had to pay, how much tax you have to pay on that estate. Now, tax is a very critical issue. If you permit me, I would want to talk about that as I
Sure,
carry on. Is
sure,
that okay?
sure.
Okay. So now, what the issue with tax is? If you have an estate larger than £325,000, what that means is that everything above £325,000 would attract a tax of 40%.
Okay.
Okay, I'm talking to those living in the UK now. So what that means is if I have, say, an estate of £500,000, 325,000 would be tax free. Anything after that would be taxed at 40%, which is really high. So
Yeah.
some people take steps to minimize that. We can talk about that later if you want us to. Ways
Oh,
people can minimize those the tax they pay on their estates. But now it would be the responsibility of your executor to now sort out your tax issue. They would have to apply for what's called the IHT tax form, obtain that form. Uh, if you died without a will, they will be applying for, they'll be using letters of administration.
mm-hmm.
They'll be applying for letters of administration. If you had a will, they'll be applying for grant of probate. Now that's for them to be able to have, that's a document that shows I have the right to administer this estate, to go about the division of this estate. So the problem, back to your question, the problem we see is often with executors. So there are some executors may not be interested. So at that point, they have to give up their rights. If there are, say, up to 4 executors, the sole executor who would be acting for all of them would need to show a document confirming that he has a right to act on their behalf. So that's about it.
Wow. So, in the now just take this scenario, the context of our local culture, where most of our mothers or our parents are not well educated, on some of these things, and you have a lot of mothers and their children being driven out of the house because sometimes the man's family will come in and say, since your husband, actually not make a will, we can now take possession of the house or anything that they both actually worked hard to acquire. In that case, what kind of rights or what kind of privileges can the woman and the children, have, or what kind of legal action can they also take, in trying to,
Sadly, some people do not know that they have rights. We see this, which is very sad. Because the truth is, if someone's died without a will, yes, he's died intestate, the closest family member can apply for a letter of administration.
Okay.
So, like the scenario you just painted, the wife can apply for that. I mean, we even had this case where we had a client who was based here. His family was in the UAE, in United Arab Emirates. When he died, his wife, God knows how long it took her, but she kept pushing and pushing until she got our contact and asked us if we could help to write to the banks. At that point, she was giving us the power of attorney to act for her.
Okay.
To contact the banks, because yes, you can write to as many banks as possible. There are times the spouses are not even sure what their wives or husband had, while alive. Some may be able to tell you, oh, I know there was a time he mentioned HSBC, and that's about it. But we can take the pain to write to all the banks. Some will write back to tell you, unfortunately, we do not have this person on record. But for this particular person, it was so shocking to see how much a bank wrote to us to say they had on record for her husband, and And she was far away, many, many miles away. But if she hadn't taken that step to, grant power of attorney for someone to act for her, yes, she felt, okay, I was in the country, I may not be able to know the steps to take. That's why you need your solicitors. Hey, contact us quickly.
Wow.
And she took the step. And today she's £1,000,000 richer, So very shocking. All she knew was he had once mentioned a bank, but the bank we even got most of the money from, she knew nothing about. Oh, that's one of the things. So sometimes people are not aware of their rights, but these things are available. If you're the closest person, in fact, there are times where the wife, as in the case you talked about, may not be able to act, and she would say, "Okay, I'm giving the right to my first child, to represent me," and do that. Yes, you are the closest link to this person. Why not?
Wow. So at what point is a will not a will?
Sorry, you broke up for a bit.
Sorry. At what point is a will invalid or a will not a will?
Okay. Now, so when drafting a will, things you must be aware of. You must be 18 years and over.
Mhm.
You must be of sound mind. So sometimes you see this where some children watch and they can see that their parents are becoming mentally incapacitated, probably with Alzheimer's, and then they start pushing, "Oh, can you draft your will now?" If that is later discovered, that can invalidate the will. Okay, then you must show that it was done voluntarily. You weren't cajoled, it wasn't out of duress. Like, yes, the good case remains this, where your child compels you, you've got to add my name to it. Because there are some parents who just feel, you were very bad, or I don't want you, all you do is drink and smoke and go do drugs, and I don't want you spending my money like that, so I'm not adding you to my will. So, but if the child has to force the parent to include his or her name, then that could invalidate the will. Then very, very critically, you must sign that will before 2 witnesses and have those 2 witnesses sign before you. Now, this one is very, very important, because the truth is there are 3 ways people could decide to draft a will. Some people could decide to just, have a handwritten will, to just write it down, write their wills, but they must be signed by 2 witnesses in your presence, and you must sign before those 2 witnesses, and that will be fine. There are some people decide to go online, download a template, pay a very small amount for it, and then but ensure that they are signed by 2 witnesses. And then some people decide to contact solicitors. It is always recommended that if your case is not straightforward, you contact solicitors. Or if you have an estate of up to £2 million, yes, you need to, because the tax issue is very sensitive, really, really sensitive. And who knows, we might just be giving you some ideas on how to minimize the tax you pay, ultimately.
Okay, having mentioned,
So
the kind of wills that we have, can you please educate us on the different types of wills that people can write? Because you said people can just
no.
have
I mean,
handwritten one, and also maybe they can just download some
yes.
also. So if there are any different types of wills that we have, I mean,
Okay.
if you can actually educate people on that. Yeah.
No, what I meant by that is a will is a will. Okay, if someone comes, picks up a paper, writes, it used to be the case, you see people do that in old times, pick up a paper, write 5 lines, I want this X amount to go to my daughter, put her name down, I want my property at this address to go to this, and that would be considered valid as long as it's signed by 2 witnesses. So a will is a will, regardless of how it's drafted, as long as it expresses the full wishes of the testator. That's what's critical.
Great. Okay,
Yeah.
so what should one never put in a will?
you should put everything that is yours. Okay, but I think I don't know why this keeps coming to mind, and I think I might just deal with it at the same time. Now, things that you must be aware of. Now, sometimes people have so much money and they feel, I'm going to draft the will myself. But maybe if you saw your solicitor, then they will be advising you, hey, you got 500,000, a property worth over 500,000. Have you considered this? So some of the things we encourage you consider is, one, you could decide to gift that property to your children, so you can you can live for 7 years after gifting that property. So what that means is you give the property to the child. If you live for up to 7 years after, then the property is now becomes theirs solely. So on your demise, that property will not be taxed because they now own the property. But if that doesn't happen, if you die, say, within 6 to 7 years of gifting that property, then they would have to pay 8% on that property. If you die within 5 to 6 years, they pay 16%. If you die within 4 to 5 years, they pay 24%. And if you die within 3 to 4 years of gifting that property, they pay 24%. Why would you want to let them pay anything if possible, as I've just said? So we're finding a lot of people now who seek advice early. They are in their early 50s, some even in their 40s, decide, okay, I've worked all my life for my children, so I might as well just gift this property to them, so it becomes theirs before I die. Then another example is sometimes you see people give to charities. Now, this is also often taken into consideration when administering your estate. If you have made some kind of donations to charities, oftentimes they would tax your estate at 36%. Then we have something called annual exemptions. Annual exemptions allows you to give £3,000 out every year. So you have people who decide to just, give £3,000 every year. That's annual exemption. Then there are small gifts of £250 to as many people as possible. So some people decide, I'm going to bless people. I want to see people's lives better. So I will gift them £250, as many people as possible. I'm just concerned about the difference it makes to their lives rather than have to pay that on inheritance tax. And then there's the one of wedding gifts. Okay, so you can gift your child up to £5,000 for the wedding. If it's your grandchild or great grandchild, £2,500. Even if you have given them £3,000 annual exemption, yes, that's still allowed. And then to any other person, you can give £1,000. So some people feel, I'm going to do this. At least it's my contribution to humanity, rather than have my estate taxed at 40%. So these are some things you could explore, you see, as when you contact your solicitor. These are some ideas we could give to you. So you have it now.
Wow. So, can someone, challenge a will or a trust if they feel?
Yes. Yes, of course. You see this sometimes where people feel something's not been right with this will. Like the examples I gave earlier, probably the person was not mentally sound at the time the will was written. You have this sometimes for people who go into care homes. Sometimes they are carers, or even people who have living carers. The carers sometimes could, raise an alarm and say, no, I saw her child constantly come here, bully her into updating her will, drafting a new will. And so they could do that. Sometimes you even have children. We have a potential case like that. But in this case, I don't think there'll be any chance for them, because the man's just decided, my children have not lived the kind of life I wanted, I expected of them. So I'm not going to add them to my will. And he is very close to, giving up. So one of his daughters is kicking up and really saying, I am going to challenge this. But yes, that was solely his decision. That's why I said she could challenge it, but the chance of her winning it would be very minimal. So there are cases where people challenge the will, of course. Why not?
Wow. So do wills, necessarily have to be probated by the courts?
Say that again, sorry.
I said, do wills have to be probated by the courts?
You mean if challenged?
Yeah, yeah.
Of course, it has to go through due process. It has to be investigated. If something is flagged up about the will, it has to be investigated. Your will must be in writing. If the person feels this will, yes, anybody could write it for you. But if the person feels the way the whole process, they had to go about the whole process was not really comfortable, they could raise that as a concern, and it must be investigated.
So at this
Definitely.
point, at what point does the trust, come in? If wills are probated by the court, at what point does trust actually come in?
It's up to trust that those are decisions people make. It's up to you if you decide to have a kind of trust for whoever. Oftentimes, parents would consider having trusts for their children. That's another way of also avoiding tax. So they decide, okay, I'm going to. What kind of trust are you considering? Is it a basic trust? What do you want to make of it? But what we see sometimes is some parents have the desire to set up trusts for their children, but sometimes they're limited with the information they have. I have seen someone who wanted to set up trust for his children, and then he realized that the property was still mortgaged. Now you cannot be setting up trust with a mortgaged property. You need to pay off. No lender would want that to happen. You still owing the lender. So much as you desire to set up a trust for your child, or you put that in your will, so that could be a fundamental problem as well. So if you put that in your will and you proceed with that, maybe with solicitors who have not done their due diligence, then it could be a problem that flags up later. I was talking about executors having to deal with administering your estate. So at that point, executors would be responsible for looking. Executors are responsible for paying your tax, your IHT tax, your inheritance tax to
Yeah.
HMRC, and then they have to deal with debts. So they could look into that issue. That's a mess they have to deal with there. Okay, because now they have this the lender who's come after them because this person is dead. So they also would have to sort out paying that person. So that at that point could be a problem. So trust must be entered into very carefully. Oh, why not? It's a decision people make. They decide what they want to do with their money.
Great. So until recently, there's when people actually started thinking deeply about life insurance and stuff like that. So with wills as well, we don't have conversations. We see, writing a will as a dangerous thing, or like a death sentence, like if there's something like that. And so how can we make people in our community be aware of the importance of writing a will? What can you do, as solicitors? What can you do to publicize this important topic, yet little is known about?
In answering that question, I must commend you first, Nana, for putting this together, because I mean, this is courageous for you to do this. We rarely talk about it. So talks like this make people more aware. As people watch this, I'm sure there are some people who maybe in their 30s, in their 40s, who would watch this and decide, hey, we need to draft a will, you know. So things like this, I know sometimes, like you were saying, okay, what can solicitors do? Solicitors are there, but you will be also surprised that some people think they don't need solicitors. So they even want to deal with their legal problems themselves until they mess it up. There are people who do that, you know. So when people like you and I also see the need to talk about this and sensitize people around us, it is important. For those who would be watching this later, share this with people in your network. So more people are aware of the fact that they need to have their wills drafted. I think it starts with us, really. Even to you and I speaking, do we have our wills drafted? And then to anyone who is watching, what steps have you taken? Because sometimes people are saying, oh, by the time I am 50, I would have had X amount of money,
Yeah.
and then I'll be able to draft my will. No, with the little you have, put that down and review it as you go on.
Great. So, where can a will be safely stored? Because you said, sometimes you have parents, because of their mental capacity, being coerced or being influenced by their relatives or their children to write certain stuff that they never actually wanted to actually put down in their wills. So just in case, in their soundness of mind, where they drafted the will without the knowledge of any of their family members, where can they safely store this kind of
Okay.
documentation?
Okay.
Where?
Well, that's a good question. You won't believe it. I know about someone who passed, and her will was found stashed in between her mattress.
Oh,
So you have people who do this, but there are people who decide to tell their friends, close friends, to tell their family. And I think this is something I also needed to mention. You can't just get somebody appoints. You must appoint an executor for your will.
mm-hmm.
You can't appoint an executor without having informed them. Otherwise, can you imagine that you're dead and they go to the executors to say, okay, it's time to draft to administer the estate, and the executor is staring like, what are you talking about? Because you should also inform the executor where you have left the will. Then there is the register for that, with Newcastle. People could decide to do that. You pay a fee for that, but some people find that it's the safest way to have their wills safe. Some give it to their solicitors, but ultimately your solicitor, to make it safe for themselves, will put it on that register, really. So that's one good option I think people can go for. But some people decide to tell their friends, very close friends or family member, this is where I have my will, in case I'm nowhere to be found tomorrow. That's where you should go for it. Yeah.
Right. I think I've got a friend sending in a question, so I'll just try to read it. This is from Bukola saying, is there an appropriate age for drafting a will? Does someone who doesn't have children need a will?
Of course, we all need wills. We all do. Like I was saying earlier, even if you're in your 20s, you've got money going through your hands. Why not? So as long as you are 18 and over,
Mm-hmm.
I mentioned that's what makes your
Sure.
will valid. For your will to be considered valid, you must be 18 years and over. Okay. And then you don't have to wait for any time. Because like I was saying, if someone is say 21 and has started working and is earning and decides to draft his or her will, that's even better because that makes this person even more disciplined. You get to the point where you're saying to yourself, oh, I will give X amount of money to, even if it's to mom or dad or my sibling, uh, uh, that's something. So if by the time I said wills have to be reviewed every 5 years, by the time this person is 26 and the person is going through it and the person realizes, okay, I need to add something to this will. Maybe the person has since, maybe is on his or her way to getting married, and thinks, okay, that's a major change. I also need to, tweak the will. If the person gets to that point and looks at it and thinks, oh, 5 years ago, I was in a position where I wanted to gift X person £20,000. And since then, I don't even have up to £20,000. So that makes this person even more disciplined. So you're looking at it and thinking, what have I done with all of that money? So really critical. Anyone 18 years and over should have a will.
Great. So I hope, Bukola, I hope that answers your question. And how do you prove someone's mental capacity? Um, at the time of writing a will, how do you know that
That the
this
person
person
had
has?
mental capacity.
Yes.
Okay. There are different ways. I mean, when it's checked, even if it's the early stages, there are people who, when they feel okay, they're now in the early stage of Alzheimer's, they feel okay. I need to draft this will before I become so forgetful.
Yeah.
Loving children of such persons would want to help the person sit down and put something in writing when the person is in a good state. They at that point in the early stages, they're in and out. So when this person is with it. So that's the time you want this person to draft to get something down. But when it's the case where, like the example I gave earlier about the carer reporting that one of the children uh, puts his or her parents, his mom, under duress, So it's obvious when, I mean, if the person has gone for a lot of medical assessments, at that point where it's beginning to look like, oh, she's becoming forgetful, he's beginning to mix things up, mix events up, So it's obvious, and they could also check with the medical report of this person, so they know when things really go worse. And in the course of investigation, they might also get the opinion of doctors as well, because especially this person's personal doctor who's been treating the person. So the doctor will be able to tell if at the time, as at this date, this person was still mentis compass. So that's one of it.
Great. So, can I use my will to disinherit someone? Can someone use their will to disinherit someone?
Okay, what it is don't forget, what's your will? Your will is about your money, your property, your possessions. It's got nothing to do with I don't want to say ownership, like you own the person, or such links. But you could decide to delist someone from your will. That's one thing you could do. If you don't mention, then that's one of the advantages. When we're talking about dying intestate, if you don't mention this person on your will, they cannot be considered. And that's why it's a problem sometimes. I was so shocked the other day. I was listening to Dave Ramsey, and he was speaking, and he said he even believes that people should read the wills before they die. There should be will reading before they die. And while I was discussing that with my husband, I was really like, this man is something else. He said for him, he's done that with his children. Everyone knows what they will get when he's gone. And that he thinks that's better than them expecting a lottery, to think that they won the lottery when he dies, and then they're shocked to find out that their names are not even on the will. So if you think, oh no, this child is going to mismanage this money anyway, all he does is abuse on drugs, on substances, I'm not going to give him anything. You don't mention. If it's not mentioned, sorry, he might be present for the reading of the will, but unfortunately, he can only throw up and cause problem for the others. And that's the kind of problem you don't want. I guess that's the kind of problem Dave Ramsey was talking about when he said you need to avoid that. So the child knows you're not getting anything because of these behaviors.
Great. So, when people have, prenuptials, or, so it's like they go into that marriage knowing what, I've already willed. So, okay, when they both acquire things together, I mean, at the time that they actually got together, but then they have this prenuptials actually signed before they actually go married. In that case, when one party actually dies, what happens to the other party?
Okay, you're talking about prenup.
Yeah.
Now, before I answer that question, I'm hoping I understand the question, but before I come back to it, for you, when I was talking about your will, I said one of the major events that may take place that should warrant the will being reviewed is the case of divorce, and then the case of one party dying. You must, because typically what you find in will is the first line is often, I leave everything to my surviving spouse, right? And the name. So what happens when this wife or husband dies? So you need to review that will to reflect that event. Okay. But talking about prenups, one thing people don't realize with prenups is that prenups must be reviewed as well. They must be reviewed. So, and this is where they lose their authenticity in courts. A lot of judges throw them out if they've not been reviewed. You can't, because you signed a prenup before you you decided to marry 20 years ago, think that you can, at the death of your spouse, just bring it up and say, oh, yes, there we go. No. So that agreement has to be altered. So things happen. But once a spouse dies, really, even when you have a will, you need to review that will. Have I answered the question?
Yeah,
If not, just ask
sure.
the question
Because
again.
no. Because I am thinking, of a situation where, let's say, you go into a marriage, but then you've got your children already. So it's like let's say this being your, I wouldn't say first marriage or second marriage, because sometimes people have children out of wedlock, but then they sign this prenuptials thing. In that case, what happens to the children? And so that's the scenario that I'm just trying to actually raise or create. So in that case, what happens to the children, and what happens to the lady that this man eventually marries?
Okay, so let me give an example, and I hope that clarifies what you have in mind. If not, you can ask the question again. So there's the case of a woman who, her husband, on his deathbed, pleaded with her and said to her, I know you're a very beautiful woman, you're attractive, and I don't want to restrict you. So I know you will move on to marry somebody else. But I want my children protected. He was a very wealthy man. So he didn't want the case where she moves into another family, becomes a blended family, and then everything is lost in there. Because don't forget, this is where we sometimes have a problem. If you're coming from your previous marriage with all of that wealth, and you bring them into your marriage, and it's not decided at the start what is what is for who, and boundaries are not drawn around that money. Once they're pulled together, they become matrimonial assets. Matrimonial assets have to be considered in the matrimonial pot, when the assets have to be divided. So even if you brought them from your previous marriage, if they were not separated, then, but when people talk about prenup, I like to always say prenup is a vehicle. There are a lot of vehicles. So for a woman like that, rather than sign a prenup with her new husband to protect her children, she could decide to put that money in trust for them. You see.
Okay. Wow. Viewers out there, this is an important discussion, and trust me, I would just urge each and everyone listening to us to share.
Have I answered your question though?
Yes, you have. Yeah, you have. And please share this important discussion, because we want our community to be educated and also to be informed about some of these topics that we find that as a taboo, to openly talk in our homes. So please share this discussion and let this go far. At least you can listen to this and maybe educate your parents on them if they are not that educated. Yes, maybe yes, you can help them on that. And also maybe to the young ones, you also don't wait till you get too old to start drafting your will. Just like Chidi said, you can even start drafting your will at the age of 25, 30. Yes. So please let us all be educated on this. So Chidi, do someone necessarily needs a lawyer to write up a will?
I was saying earlier, some people decide to have a handwritten will, some people decide to download a template online. But it becomes very important for you to have a lawyer if your case is not straightforward. Okay, like the case you talked about, which involves like a blended family, you need to be speaking with a lawyer, right? If you have, I know that they would often say that's what they use for discretion. If you have an estate of up to £2 million, you should be speaking with a lawyer. Well, I think really, if you get to that point where your estate would attract inheritance tax, you need to speak with a lawyer. There are pointers they will give to you, like I shared earlier, that will help you save a lot on tax. So why not speak to a lawyer today?
Great, because I had to just remind viewers who just joined in, just in case maybe they miss out on the beginning. And I also asked because sometimes we get frightened, by the legal fees and stuff like that. So,
And truly, it doesn't cost much,
so how
really.
much does it cost then?
No, no,
to
it depends. There are different lawyers, okay, and they
okay.
charge differently. But it shouldn't cost much. And if you think about it, think about the safety of what you're doing, as opposed to paying just a few pennies to a lawyer. I'll call it few pennies. So why not? You need that peace of mind to know I've done it right, and it cannot be invalidated.
Great, great. So, what should someone bring to the initial for the initial consultation? What are some of the things that people can bring if they want to actually write a will?
Okay, so the first thing we'll be asking you is who will be your executors. Okay,
Okay.
so you need to think about that. If, like the example I gave earlier of the woman with one child, what
Mm-hmm.
happens if that child predeceases you? If that child dies before you? So who would you want to be? We recommend at least 2 executors. You can have as many as 4 executors. So you need to think about that. Your executors can benefit from your will. Yes. Executors could be uh, your close friends or relative. It's up to you who you want. Or you can go for professional executors like solicitors.
Mm-hmm.
Um, so you think about that. Then you think about who will be the beneficiaries.
Yeah.
Who do you want to benefit from your assets as you have all of these assets? And what do you want each beneficiary to take? Then who will be your witnesses? Your witnesses cannot benefit from your will. So you cannot be mentioning them as beneficiaries at all. No, they don't stand to get anything. Executors can, your witnesses cannot. There's another issue I think has just come to mind, I must mention, and that's the issue of guardianship, right?
Okay.
Because if you have young children, for you have people who are very poorly, they're ill, and they are maybe going towards their end of life, and they have very young children. So
Mm-hmm.
this becomes very paramount. In whose care do you want to leave your children? You want to think about that. So if it's a case where you have 2 parents who have split up, they're no longer together,
Yeah.
father may want to appoint a guardian he trusts. Okay, and mom may want to appoint a guardian she trusts. So in that case, it's okay. We can have 2 guardians. Who are guardians? They are people who make decisions for your child. So what you'll be doing by appointing them as guardians is bequeathing parental responsibility to them. So
Mm-hmm.
if I'm not here, you can make as you can make just as any decision as I would for this child, even major decisions. Okay, so they take on it, and this is very sensitive, and that's why you must think carefully who you want to appoint as a guardian. So, in a case where you're not together, both parties could decide to appoint their own guardians to
Great.
ensure the safety of the child, the well being of the child.
Great. So, is there any area um, of our discussion that maybe I wasn't able to talk about because this is your field, that maybe you want the public to know about in terms of wills,
Hmm.
probate, trust, and testament? Yeah, before we end tonight's discussion, and also an opportunity to leave your number and also talk about um, your company. I mean, if anyone actually wants to contact you for any issues at all, yeah. So if you can take it.
Okay, nothing really is coming to mind, but really, I would like to say thank you, Nana, for putting this together, and I hope our viewers will share this with as many people as need the information. We all need to start thinking about our wills. Let's not wait until we're close to retirement. You know, uh, do it, just do it today. And sometimes, we keep procrastinating. You're thinking, oh yeah, I'll do it, and I'll do it, and then the years just keep going by. Just get on and do it, and ensure that you review it as you go on. I can be contacted through link. I'm on LinkedIn. I'm on Twitter. You can send me a DM. I could leave my email, Chidi at Elkettas Associates.com.
Mm-hmm.
Feel free to contact me, wherever you find me. I mean, I will pick it up, and I sure will respond.
Great. To our lovely family out there watching us, if anyone has got any legal issues, any immigration issues, I mean, any family issues, any issues at all that you want lawyer Chidi Akunna to help you with, please don't hesitate to contact her on LinkedIn, and also you can look for her firm. It's called Elkettas and Associates Solicitors, and Chidi Akunna. Yes, we'll be more than happy to help you. And so I just want to read a few comments from people who just joined in. I've got Foundation for Family Affairs saying great session. Thank you so much. And I have Sage A also saying beautiful. And I've got Bukola also saying great info. Thank you so much. And I've got Relationship Builders Forum says very useful information. Thank you for sharing this information. And I've got Relationship Builder Forum also saying amazing. And I've got a few others. Oh, I think Bukola, okay, says, thinking about the person who had their will under their mattress, who needs to know you have drafted your will and where it is. Yeah, I think maybe, I don't know whether maybe it's a question, but it says, thinking about the person who had their will under their mattress, who needs to know you have drafted your will and where it is.
Yes, you could tell your friends or family about it, or the safest place is just put it on the register. Yes.
Great. If I can have the next. Okay, I've got my own brother also from Palm TV UK saying educative program. Thank you so much, Pastor Augustine Abwaji. Thank you so much for your support. Yes. So on that note, and sorry, yes, another one from Thelma saying I would have to rewatch the session. I missed quite a lot of information. Yes, Thelma, please to take some time out and watch this session. And trust me, you come back and thank Chidi Akunna. And I've got Maverick saying this demystified wills. Thank you. Yes, I think majority of us are scared of wills. Majority of us, because we see it as something too dangerous, something that we are not too brave to sit down and like just like you said, it's a huge reflection and it's a bit nerve-wracking, and I think like most of us, we don't want to sit back and go through that mental torture. So thank you for demystifying wills for us tonight. So once again, thank you so much for educating us. Thank you. I'm so grateful, honestly, from my heart. So grateful to you.
Thank you, Nana. Thank you to everyone. I saw some of my lovely people there. Thank you so much.
I know you are so busy, a mom, a wife, a full-time, solicitor, and yet you're so humble. And thank you so much.
Thank you.
And I know if I come knocking on your door once again, you come back and educate the Inside View family. So once again, thank you and happy new month.
Thank you for having me.
Yes. So to anyone that that's joining, I say thank you for your company once again, and take care. Good night. Bye-bye.